Welcome to the CaseBank 7-minute update containing cases added to the database during the month of October 2020. 1. A long discussion of the sufficiency of evidence needed to support a conviction of soliciting or recruiting a person to join a criminal street gang under PC 186.26. This case, the evidence was overwhelming. Case 2. Prosecutor prevented from giving defense Brady reports regarding an evidence code 1108 minor witness because of Welfare and Institutions Code 827. Held. In this situation, the prosecutor's Brady obligation was to tell the defense of the report's existence and to tell the defense that the report is exculpatory, without giving the defense any details as to how and why it is exculpatory. Case 3. The Department of Corrections recommends to trial court that it recall defendant's 23-year prison sentence per PC 1170D sub 1 due to the defendant's exemplary prison record. Held. This recommendation does not trigger a right to a hearing or a right to an appointed attorney. Trial court does have discretion to order either or both of these things. Case 4. Penal Code Section 859.5 imposes standards for the recording of suspect interviews in some cases. Held. The 2017 amendments to 859.5 are not retroactive. Estrada reasoning does not apply. Case 5. Defendant enters into a 10-year plea bargain that included 2 one-year priors under 667.5b. Then 667.5b is amended, making it not applicable to the defendant. Defendant wants an 8-year sentence. Held. No. Prosecutor has a choice. Accept 8 years or go back to square one and renegotiate. Case 6. After giving statement to police and after testifying at prelim, the victim learns of an immigrant visa available to domestic violence victims and seeks and gets such a visa. Held. Yes, this is marginally relevant, but trial court's decision under 352 of the Evidence Code to exclude this is upheld. Case 7. If the defendant's unreasonable but honestly held belief in some fact negates a necessary specific intent for crime X, then the defendant does not have the specific intent. There is no requirement that the defense belief be reasonable. This case involved burglary. Case 8. Video of crime admitted as an exhibit was grainy, poorly lit, and things happened fast. Detective viewed it 50 times, including very slow motion, and told the jury what he saw. Held. This was not improper. This was just a guide to assist the jury in their own viewing. Case 9. Defendant sends child porn as email attachments through Gmail. Artificial intelligence program at Gmail looks at all attachments and sends suspected child porn to police. Held. Gmail is not the government. Fourth Amendment does not stop private company searches. Police may look at what Gmail gives them. Case 10. Defendant is charged and convicted of molesting child A. Then child B comes forward. Defendant charged and convicted on molesting child B during the same time period child A was molested. Held. PC 667.61e, multiple victim of the one strike law, does not apply. It requires both victims to be charged and tried together. Case 11. Holdout juror excused for failure to deliberate. Reversed. Yes, the juror was fairly uncommunicative and failed to articulate rational reasons why she disagreed with the others. But, held the DCA, she was not totally uncommunicative. She tried to deliberate. She was just very bad at it. Case 12. Using fraud to persuade someone to not report a future crime to the police is not a violation of Penal Code Section 136.1. The statute is ambiguous regarding future crimes, and the DCA invoked the rule of lenity. But it is a violation of Penal Code Section 137 sub B. Case 13. 10 years ago, public defender declared a conflict and represented defendant's co-defendant. Defendant now seeks Penal Code Section 1170.95 relief, and the public defender is appointed for that purpose. No objection made by anyone. PC 1170.95 petition was denied. Held. No automatic reversal due to conflict. Defendant must show prejudice. If you wish to download a PDF of all the cases added to the CaseBank database during the month of October, or if you wish to download the entire 20,000 case database itself, go to our website at casebanklaw.com.